Ready for the dictation? Start. Perusal of the power of attorney in question as whole indicates that it is a general power of attorney executed in favor of the petitioner to take care and manage the subject matter of the deed, including its rental and alienable right. In clause 1 and 2 of the deed in question, attorney petitioner has been authorized to manage the subject matter of deed as if it is done by donor and given restricted power of alteration with caution not to cause harm to the walls, roof and floor of flat. Clause 8 and 9 of the deed further clarifies the intention of the donor so far as the applicability of the provisions as enunciated under Article 48 EE of Schedule 1B of the Stamp Act is concerned. In my opinion, it is not attracted in the present matter. The recital made in clause 1, 2, 8 and 9 of Power of Attorney dated 15/12/1994 succincts the restricted authority granted to the attorney to renovate or reinvigorate the flat in question with caution, and the principal has reserved all rights to revoke the power of attorney in case of dissatisfaction with the work of attorney appointed. Meaning thereby deed in question dated 15/12/1994 cannot be treated to be irrevocable. Language of general power of the attorney in question is immaculately clear that intention of the executant is to confer the approved power of agency under the condition of revocation of deed in case donor is not satisfied with the work of donee. In case it is treated to be an irrevocable authority, petitioner will be liable to pay the stamp duty as per the provisions of Article 23A of Schedule 1B of Stamp Act, which is applicable for the conveyance. It would not be out of contest to quote the definition of conveyance and instrument as enshrined under section 210 and 214 respectively of the Indian Stamp Act as follows. Conveyance includes a conveyance on sale and every instrument by which property, whether movable or immovable, is transferred inter vivos and which is not otherwise specifically provided for by Schedule 1st, Schedule 1A or Schedule 1B as the case may be, an instrument whereby a co-owner of a property having defined share therein transfers such share or part thereof to another co-owner of the property is, for the purposes of this clause, an instrument by which property is transferred. Instrument includes every document and record created or maintained in or by an electronic storage and retrieval device or media by which any right or liability is or purports to be created, transferred, limited, extended, extinguished or recorded. After going through the recital in the deed in question dated 15/12/1994, I am of the view that it is a revocable authority given to the petitioner to do any transaction, whether it is sale or rent or taking care and manage the property, etc. There is nothing in the deed in question to demonstrate that authority has been given to the donee for some consideration or due to non-irrevocable status of the deed, the property in question, vested in the donee and he became full owner of the said property. Apart from that, authority granted by the principal to the donee cannot be said to be coupled with an interest held by the agent. Stamp authorities have misread and misinterpreted the recital in the deed and illegally dragged it into the clutches of the provisions as enshrined under Article 48 EE of Schedule 1B of Stamp Act. As such, mere execution of general power of attorney by a person would not ipso facto imply that any transfer of property as defined in the Transfer of Property Act, that in general power of attorney, even if it is provides for power of attorney holder to convey title on behalf of the grantor or deemed to be irrevocable, cannot be recognized as deed title. From the perusal of the power of attorney in question, it would not be inferred that it is irrevocable in the hands of donee. Stop.